We created an online bulletin board where you could see in your area, where pilots are going. You would just be able to reach out to the pilot and coordinate to meet at the airport, and then right from there you could share expenses directly from the app.
When a Flytenow pilot shares expenses with his or her passengers, there's no commercial component. All they're doing is offsetting the costs of the flight. And if there's 2 passengers, the pilot has to pay a pro rata share, 50%. If there's 3 passengers, they have to pay 33%.
The way we started was the way every company starts, right? We walked out to local airports. We actually grew the pilot base, and then we had a lot more enthusiasts interested in going flying. So from there, we actually applied to Y Combinator. And what happens at the end of 3 months is you end up pitching your business to the who's who of Silicon Valley. And it's not uncommon for companies to leave demo day with at least with around $1 to $2 million in a seed round committed. 3 days before we're actually going to pitch our business at demo day to all the big investors, the who's who, we actually get this letter. So to back up here and kind of explain that, so we had learned that the FAA had reached out to several of our pilot members and was essentially telling them not to post on Flytenow. I reached out to them and just wanted to get confirmation that what we were doing was correct. From our viewpoint, nothing's changed here. We literally took a physical practice and just made it way easier online. The crux of the FAA letter was that a pilot could not communicate his travel plans online.
The FAA takes a look at this, looks and says, my best analogy is, this looks like how airlines advertise ticket prices. Therefore, these Flytenow people are basically operating an airline. They have not gone through any of the regulatory process. They don't have permission from us to do this.
And because they communicated to such a broad segment of the population, they were then common carriers, and common carriers have to have a regulation or a regulatory compliance that has a whole host of requirements attached to it that simply wouldn't make this model feasible.
The rules in the books are very clear. We're expense sharing, and there's nothing wrong with that. It's been happening since the beginning of general aviation. The only thing that's changed here is we took that from a physical bulletin board and put it on an online bulletin board. We couldn't ethically pitch to investors with this letter out there, obviously. So we had to kind of regroup and think about what the next steps were. They were either obviously shut down, or option B, can we fight this letter and can we win?
Case number 14-1168, Flytenow Inc. Petitioner versus Federal Aviation Administration Administrator. Mr. Riches for the petitioner, Ms. Foster for the respondent.
Right, we heard from the FAA that, at oral argument, if you had 50 friends on Facebook and communicated a flight to them, that'd be fine. But if you had 150 or maybe 500 friends, then it would get a little bit more gray.
We have to look to see whether or not someone is a common carrier, and that requires an analysis of whether that person is holding out.
So if somebody has Facebook and they're in anybody who sends them a friend request, they say, yes, you can be my Facebook friend, that would be impermissible. But if they, limited themselves to only 10 friends at a time or 50 friends at a time, then they wouldn't be holding out to the public. I'm trying to understand what the rationale is here.
The agency's position is that it is a context-specific kind of analysis. There may be some cases where it's a close call whether something is public or not.
We believe it's a fundamental threshold question. Unlike Airbnb, these pilots can't pursue a profit. They're just sharing expenses, which has been permitted since the beginning of flight.
The agency reasonably concluded that there was holding out to the public because these flights are posted on the website that are accessible to any member of the public who simply applies for membership.
So we went into the case thinking we had very strong arguments. But when we actually got the opinion back from the court, we were pretty shocked to realize that we were not able to have the merits of the case be addressed by the court. It comes down to an aspect of the law, a doctrine of the law called regulatory deference. And what regulatory deference says is that when an agency like the FAA makes an interpretation of its own regulations, then the court really can't take a deep look at it.
Flytenow takes the takes it to the Supreme Court. The Supreme Court decides not to hear the case, which then puts Flytenow in a position where they have no other legal recourse.
So once you redefine the term common carrier, and you say that Flytenow falls under this common carrier burdens, this air carrier burdens, you've now triggered, dozens, if not hundreds of pages of new FAA regulations.
But the real question is, how do we make regulation work for innovation better, right? How do we pair the regulator with the innovator? I think regulation has to exist and it has to have its place in business. So I think, if we can come together as regulator and innovator and think about what are the best ways to solve those problems, everybody wins. What's also happening to consumer choice and the ability to be able to connect with somebody and live life the way you want to live it?